Thank you for tuning into Bond Court. I want to continue posting Bond Court every night on YouTube, but the viewership and engagement on my channel has fallen off a cliff. I would greatly appreciate your help by hitting the like button and leaving a comment on my videos. Thank you and enjoy the show.
All parties are present. Next case is Joel Kennett. Mr. Kennett, the court, you were picked up for a warrant for failure to appear, and the court is ordering the bond to stay set at no bond. Christian Cal.
Yes, ma'am.
The court finds probable cause for petty theft. Bond is stayed at $500. You ordered to not return to the location where this incident occurred and have no contact with the victim.
Yes, ma'am.
Maurice Clark. The court finds probable cause for trespassing and orders the bond to stay at $500.
Your Honor,
Yes?
the state has extended an offer of an adjudication of guilt credit for time served for cost of no return, in which Mr. Clark would like to enter a plea of no contest.
While that is acceptable, I just feel I need to inform you, the court plans to revoke the bond on the out-on-bond case and set a higher, a bond of $1,000 on count one and $150 on count two. Does he still want to take that?
Yes, ma'am.
Yes, Your Honor.
All right, that's fine.
Excuse me, Judge. The state took no action on count two.
Okay, the court will not order the bond on count two as the state took no action on count two per the jail staff. All right,
May I approach?
you may. Mr. Clark, is this your signature at the bottom of this plea form?
Yes, ma'am.
Did you read this document before you signed it?
Yes, ma'am.
Are you under the influence of any alcohol or drugs and medication?
No, ma'am.
Do you understand a conviction on this case will subject you to being deported if you're not a U.S. citizen?
Yes, ma'am.
All right, there is a sufficient factual basis. You're alert, you're intelligent, you're adjudicated guilty. How much time, sir?
2 days.
Ordered to serve 2 days in jail with credit for the 2 days you've already served, and you're ordered to pay mandatory court costs, which must be paid within 180 days of your release. I am releasing you as to this charge. However, I'm revoking the ROR on your out-on-bond case and ordering a bond of $1,000 as to count one, no action as to count two, since the state took no action. You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Do you have any questions?
No, ma'am.
Thank you, sir.
Welcome.
Raymond De La Cruz.
His mental health.
All right, reset for tomorrow due to mental health reasons per jail staff. D'Angelo Johnson. Mr. Johnson, the court finds probable cause in your case for petty theft, and bond will stay set at $250. You're ordered to have no contact with the victim and not return to the location where this incident occurred. Thank you, sir. Brian Parsons. The court finds probable cause for petty theft. Bond stays set at $500. You're ordered to have no contact with the victim and not to return to the location where this incident occurred. Thank you,
Honor,
Mr. Parsons.
I apologize. Can you repeat the bond amount?
$500, it stays. Gustavo Blanco. Mr. Blanco. The court finds actually, you were picked up on an out-of-county warrant from St. Lucie County, and there's a no bond status on both counts, and that will remain.
I already had a lawyer working on that.
I did appoint the public defender to represent you, sir.
Yeah, but I already had a lawyer working on it.
That's fine, and,
And then
That's fine. You'll be transported to St. Lucie, or the lawyer is able to reduce, or to get you a bond, then you can bond out.
Is there any way you could give me a bond?
Not today. Henry Lee Brand. Mr. Brand, you were picked up on an out-of-county warrant from Brevard County. Your bond will stay set at $4,000. Thank you, Mr. Brand. Antoine Hill. Mr. Hill, you were picked up on an out-of-county warrant from the Highlands County. Bond will stay set at no bond on both counts. Thank you, Mr. Hill. Mr. Lafferty. Reset due to behavior issues for 24 hours. Vincent Stouter. He's also behavior. Reset due to behavior issues, 24 hours. Robert Nickerson.
Yes, ma'am.
Mr. Nickerson, you were picked up for driving on a suspended license with knowledge, and bond will stay set at $500. And there's an on-view violation of probation, and bond is set at no bond. Thank you, sir.
Judge is currently out on bond.
I don't have, no, that I don't have. So can you provide that information to the clerk?
Yes, Your Honor. He's out on bond on case number 2022 CF 010-45180.
Madam Clerk, can you see if an information's been filed? And if so, print it for me? No, sir, no information has been filed. All right, no action. Tyrone Riley.
Yes, ma'am.
Mr. Riley, you have, as to your first case, the court finds probable cause for count 1. Possession of a firearm by a convicted delinquent, bond stays set at $150. Count 2, possession of methamphetamine with a weapon, bond stays at $15,000. Count 3, possession of cannabis, bond stays at $100. Sir, you also have another case of no valid driver's license, bond stays at $500 on that case. You have an on-view violation of probation for which bond is set at no bond. And you had an outstanding VOP warrant for violation of conditions as follows: failure to pay restitution, testing positive on or about 3/11/22, and testing positive again on or about 3/11/22. Bond stays set at no bond on that violation of probation warrant. Thank you, sir. Frankie Rivera. Mr. Rivera, in your case, you're charged with violation of probation. You were picked up on your warrant for a new law violation on or about 3/26/22 for knowingly receiving stolen property. Bond will stay at no bond. It does appear that he is represented by private counsel. I saw somewhere where a notice of appearance was filed in this case. Oh, here it is. The public defender is not appointed. Liliana Rodriguez Star. The court finds probable cause for disorderly conduct. You're ordered to not return to the location where this incident occurred.
Your Honor.
Bond, yes, ma'am?
The state has extended an offer of an adjudication of guilt credit for time served in court costs in which Ms. Rodriguez would like to make a no contest plea with the court accept that.
Yes, yes, ma'am.
May I approach?
You may. Ma'am, is this your signature here at the bottom of this plea form?
Yes, ma'am.
Did you read this plea form in its entirety, ma'am?
Yes.
Are you under the influence of any alcohol or drugs or medication today?
No, ma'am.
You understand a conviction on this case will subject you to deportation if you're not a U.S. citizen?
Yes.
There is a sufficient factual basis. You're alert, you're intelligent, you're adjudicated guilty. How much time served?
1 day.
Ordered to serve 1 day in jail with credit for the day you have already served. And you must pay mandatory court costs within 180 days of your release. I am releasing you as to this charge. Do you have any questions?
No, ma'am. Thank
You
you.
have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Ma'am, there is a condition also, and that is that you not return to the location where this incident occurred. Thank you. Are there any other matters, Madam Clerk? All right, court stands in recess.
Good morning again. This is Dalia Romero, Spanish interpreter, already sworn in today.
Good morning again. This is Judge Allen. We're beginning the initial appearance session for Orange County. Counsel for the Public Defender and Counsel for the State announce your presence.
Trustee Tyner for the state of Florida. Dominique Cunningham for the Office of the Public Defender.
Luis Armando Baca Guevara.
Yes,
Sir, in your case, the court finds probable cause for the offense of driving under the influence, and bond stays at $500. The court revokes the bond on your other case and sets bond at no bond. Oh, I am appointing the public defender to represent you in your case, sir. Bond is no bond on the other cases. No bond. But yes, there are two, and both bond is no bond. You got it? Okay, all right. Onel Cruz Gordos.
yes,
Mr. Cruz Gordos, the court finds probable cause for grand theft motor vehicle charge, and bond stays at $1,000. The court, you also have an on-view violation of probation, for which bond will stay set at no bond. And I am appointing the public defender to represent you. Thank you, sir. Okay, Madam Interpreter, I am being told that we have concluded all of the interpreter cases. Thank you.
thank you so much, Your Honor. Have a great day.
You do the same.
Thank you.
Miriam Andronic. Miriam Andronic.
Morning. Good afternoon, Your Honor.
Good afternoon, counsel. Go ahead and state your presence for the record as we wait for the defendant to arrive.
Thank you, Your Honor. My name is Lisa Augsburger from Bush and Augsburger in Orlando. I also happen to be the neighbor of over 15 years for Ms. Andronic.
All right. Ms. Andronic, the court finds probable cause in your case for the charge of battery, domestic violence, and we have the witness, so let's swear the witness in.
Hi, my name's Eugene Andronic.
Raise your right hand to be sworn in.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
So you're a little tall, and I need you at that microphone. I
Yes.
can't hear you.
yes,
Okay, I can hear you now. I'm sorry, that's uncomfortable. What's your name?
Eugene Andronic.
Thank you, Mr. Andronic. We need you to talking into the microphone. The lawyers may have questions, okay?
Okay.
Good morning. You
morning.
were a witness of this, or,
I'm the husband of Miriam.
okay.
So,
Your Honor, the victim is actually the son. So I don't have any questions for the witness at this time.
All right. Counsel, do you have any questions for this witness?
I would just want to make sure you don't have any objection to Miriam returning home?
no,
And it's
not
your
at all.
understanding that both boys are over 18 years old?
Yes, ma'am.
And they don't have any problem with Miriam coming home?
No,
Thank you, Your Honor.
All right, sir, is Noah and
Rodriguez.
Rodriguez your son?
it's my stepson.
Okay, thank you.
Your Honor, I spoke with counsel. I wanted to let the court know this incident actually occurred in the presence of law enforcement after the defendant had called the police herself. They were there handling another situation when this instance occurred and the arrest was made. I've spoken with counsel and they've informed me that the son did not pursue charges and does not have a problem with the mother returning home, and that if the court does have issue with that, they would be willing to stay somewhere else since they are over the age of 18. This instance occurred in front of law enforcement, and law enforcement witnessed it. That's who decided to proceed with charges, and the son was not cooperative with victim reporting or testimony at the time of the incident.
Thank you. All right, the court does find probable cause for the offense of battery, and the court will order a bond of $500. The defendant is ordered to have no hostile contact with Noah, the victim in this case, and no hostile contact with any other members of the family that live at that residence. The court is further ordering that the victim possess no weapons and no firearms and surrender any weapons or firearms to law enforcement within 24 hours of release.
Ma'am, may I speak for a second?
Go ahead.
Ma'am, I know this got a little bit overhand. She's not a bad mother.
You need to go ahead and speak into the
I'm
microphone.
sorry. This never happened before, and this is one of those times, and I don't want my wife to be punished in that kind of matter. I think it was an
Okay, hold on one moment. No, your wife is not being punished yet. Your wife is actually being released on a bond,
Okay, good.
okay?
Yeah,
And because she's being released on a bond, that gives you an opportunity, she an opportunity to consult with an attorney and prepare the defense that she believes is appropriate in the case, and you have the attorney standing right here.
fair enough. Thank you.
All right, thank you.
Thank you, Your Honor.
David Keister,
Yes, ma'am.
the court finds probable cause for battery on a corrections officer. Bond stays at $2,500.
Just a second.
I need these.
I'm sorry, Your Honor, which defendant is this?
David, Madam Clerk.
And the bond amount was? Thank you, I apologize.
Raj Kumar Suknandan.
Yes, ma'am.
The court finds probable cause for count 1, attempted murder. Bond stays at no bond. Count 2, fleeing and attempting to elude. Bond is set to $4,000. And count 3, the court does not find probable cause. State, do you want me to give you 24 hours to develop probable cause or provide more information on this throwing a deadly missile?
Yes, Your Honor, we can do that since he's being held at none on the others.
Okay. All right, court will not make a finding and just reset count 3 for 24 hours. As to the second case, resisting an officer without violence, the court finds probable cause and bond stays at $500. The court is ordering, as a condition of release, that the defendant have no contact with the victims, not return to the location, possess no weapons and possess no firearms, and surrender any weapons or firearms to law enforcement within 24 hours of release. No. Count one, none. Count two, 4,000. Reset for 24 hours. Billy Robinson?
Refused.
All right, per jail staff refused, we'll reset that for 24 hours. Elijah Dixon?
Yes, ma'am.
I still don't have a VOP affidavit. I need the Elijah Dixon. Yeah, it may be an on view, but then I don't have the facts of the case. I have no idea what happened. It's so hot in here.
No, they have the VOP. She doesn't have that.
Am I able to get that information?
Your Honor, if I may,
Yes.
I do have the case number.
So confusing. State, is this gentleman being accused of violating probation on or about September 8th, 2022?
Okay. I have the affidavit, and it references case number 2017 CF 7697. When I checked that in our system, it's closed. It says that they offered reinstatement, but that there was a plea to the bench and the defendant was given credit. So I'm not even sure if this probation is still open. It's from 2017. And the affidavit I have does not give any specifics. It just says that he was violated on that case and that the violation of probation affidavit is to be filed in front of the Circuit Judge Renee Roche for Orange County, referencing that case. So I'm honestly at a loss.
You mean 932 AA? You mean 932 AA? It says 2022 MM 932 AA. Yes, print that for me.
Clerk, what was that case number?
So in the VOP affidavit, they have 932 AA. So I think that might be they might have transposed the numbers by mistake.
Okay, I see the battery. I have the battery pulled up now.
So how do I know that this is the case that the officer believes violated the probation? Is there anything in this little blurb that he wrote in his affidavit that refers back to this 2022 MM392 AA case, because I just don't see it.
Let me see if the charges match maybe, but. Your Honor, according to the affidavit I have, it does not match. There's no way to match the case
Well,
reference.
that's why I asked if the date is this September 9th date, because that's the, well, it says September 8th is when this misdemeanor battery case occurred, but the officer wrote in his affidavit, September 9th. Which could be a typo, but
The best I can assume is that he referenced the incorrect case number as to which case was being violated.
okay, so that's a separate issue.
Yeah.
I forgot. No, so we have two issues. One issue is what exactly violated the probation, and the second issue is what case is he actually on probation on. So I have here an affidavit for violation of probation that makes reference to a case or an offense occurring on September 8th, 2022. And it is sworn to by an officer. And so since it's sworn to, it holds a substantial degree of, the court feels it's he swore to it. Now, the case number that he put on here is the 2017 CF 7697AO case. But this is sworn to and dated September 9th. Now, I don't know if they've given it to the judge, because usually they want to give these back to the judge who put the person on probation, for the judge to sign it. And I usually don't go looking and trying to figure out, what's going on with the probation. That's for a probation hearing. I just want to know if somebody's swearing to this person violating their probation. And so this officer swore to it.
Yes, Your Honor, just that he's failing to live and remain at liberty without violating any new law. Best I can assume is that this case from September 9th for battery violated his probation, and that's what the officer's swearing to.
Okay, so on or about September the 8th or September the 9th, sir, you were accused of violating condition 5 of your probation by failing to live and remain at liberty without violating any law and committing a new law violation of battery. And the court will order the bond to stay set at no bond.
Your Honor, may I be heard?
Yes, ma'am.
Your Honor, because we're here at initial appearances, we're required to stay within the four corners of the affidavit. There's been a lot of looking and digging to try to find things. So we would ask for no probable cause to be found and for him to be ROR'd, because within the four corners of the document that was provided, and the state was also given 24 hours to provide additional information. That information was not given to the court. The court had to go trying to find it, and now it seems as though there may be a little bit of assumption going on. So we would ask for no probable cause to be found for that reason and for him to be ROR'd.
There's no assumption going on. There is a police report and there is an affidavit for violation of probation, and I've read them both. There is no assumption going on.
I understand, but we can't.
There is a date on the police report of September 8th and a date on the, this may be my interpretation of what he wrote, of September 9th on the affidavit that the officer signed, the probation officer signed. However, that could just be him referring to the date that, oh, no, it's correct. He also says that the offense occurred on September 8th, but that the offender was arrested on September 9th. So that makes it even more correct. So when the court looked at it, and I'm looking at the September 9th date and looking at the September 8th date, I'm having trouble reconciling it, but I have no trouble reconciling it when the probation officer actually did write that the offense occurred on September 8th. But for some reason, the offender was not arrested until September 9th, according to this. So that's what happened. There's no assumption. Bond will stay set at no bond.
It's gonna be.
Yes, ma'am.
Like I told you.
Okay.
I understand, and I told you before you took the vehicle.
There you go.
You're gonna have to.
Thank you. I hate that you have to, pull all that stuff out for me instead of me finding it myself, but it's hard for me to find it, so.
Which is a violation.
Caddy Owl City,
Miss, you guys said I violated Section 5 with being at liberty
sir,
at home.
you're excused. Caddy Owl City. Caddy, K-A-T-T-Y. Owl City, the Creole interpreter case.
Oh,
It may be Alcide or Alcide. I may be mispronouncing the last name.
let me put that over there.
Do we have the interpreter yet? All right, Miss Interpreter, we're going to swear you in.
Sure.
Do you solemnly swear to translate from English to Creole, from Creole to English to the best of your ability?
This is the interpreter. I can hear very far away.
She said you sounded far away.
All right, Miss Interpreter, do you swear or affirm that you will translate from English to Creole and Creole to English to the best of your ability?
I know. I do.
Let's do a sound check, Miss Interpreter. Miss Caddy Alcide, can you hear the interpreter? Miss Interpreter, you need to interpret that.
Miss Caddy, est-ce que vous êtes capable d'entendre interprète là?
Oui.
Yes.
Miss Interpreter, could you hear Miss Alcide?
Yes, I can, Your Honor.
All right, and state, let's do a sound check.
Trustee Tyner for the state.
Could you hear the state, Miss Interpreter?
I did.
All right, and defense, I assume since you're standing right beside Miss Alcide, she can hear you too.
Yes, Your Honor.
All right, Miss Interpreter, this is the judge. At this time, please repeat what I'm saying. Miss Alcide, the court finds probable cause for count 1, aggravated battery. Bond is set at $5,000.
Madame Cassidy, court la joint cause qui probable pour action numéro 1, tant que pour bat et puis attaque, et yo mette caution pour $5,000.
The court finds probable cause for count 2, battery, domestic violence. Bond is set at $500.
Et court la joint cause qui probable pour compte numéro 2, pour bat et puis violence domestique, yo mette caution pour $500.
The court finds probable cause for count 3, burglary of an occupied conveyance. Bond is set at $5,000.
Et tribunal la joint cause qui probable dans compte numéro 3, tant kou vol nan un propriétaire qui occupé et yo mette caution pour $5,000.
The court finds probable cause for count 4, aggravated child abuse. Bond is set at $4,000.
Et puis et tribunal la joint cause pour compte numéro 4 et domestique violent avec un petit moun ou abison petit moun et tribunal la mette caution pour $4,000.
As conditions of bond, the court is ordering that you have no contact with the victim or the minor children in this case.
Et pour condition pour caution, et tribunal la mandé pour pas faire aucun contact avec victime non ou bien aucun petit moun qui mineur.
The court is ordering that you possess no firearms and possess no weapons.
Et tribunal la mandé que vous pas aucun arme qui vous tirer, vous pas aucun arme du tout.
The court is ordering that you surrender any firearms or weapons in your possession to law enforcement within 24 hours of your release.
Et tribunal la mandé que pot zam ou ta gagné, que pot zam pour tirer, pour lâcher yo avec et moun qui en charge dans la police entre 24 heures dans les au fin lagé yo.
Court is ordering that you not return to the location where this incident occurred.
Tribunal la recommandé pour pas retourner dans location côté incident ça t'est fait là.
The court is ordering that you maintain a separate residence from the victims.
Et tribunal la recommandé pour kembe yon résidence qui séparé avec victime nan.
If DCF is involved in this case, you must also comply with any DCF plan.
Et si département famille avec ti moun, si yo impliqué dans cas ça, ou supposé conformer ou avec aucune obligation, yo rien.
I am appointing the public defender to represent you in this case.
Moi apprendre yon défense publique pour représenter ou dans cas ça.
Thank you, ma'am.
Your Honor, can you add a one-time return with law enforcement?
The court will authorize a one-time visit in the presence of law enforcement to recover any personal belongings.
Thank you, Your Honor.
Et juge et tribunal là y a appointé ou yon visite yon seule fois dans présence yon police pour capable chercher bagay ou yo.
Thank you, ma'am.
Merci madame.
Thank you, Miss Interpreter.
You're welcome, Your Honor. Thank you for using our services. You have a wonderful day.
Your Honor. Hold on one second. Your Honor, so you don't live with him? No. Okay, so then you're fine. No question, Your Honor. Thank you. You're fine. You can,
Shaki Farhi Mohammed.
you can go back to your apartment. You just can't go back there.
Good afternoon, Your Honor.
Good afternoon.
Your Honor, the state has an update regarding this case's probable cause.
Yes, ma'am.
I reached out to the officer, and unfortunately for us, but fortunately for the defendant, the drugs have already been sent to FDLE, so there will be no testing and weights available today.
So the court finds probable cause for simple possession of marijuana. Bond is set at $500.
And Your Honor, I'm not sure if we set the bond for count 3 yesterday.
I don't remember there being a count 3 yesterday, and I don't see a count 3 today.
Okay.
There's only one count.
Okay, I just wanted, I'm mistaken. I apologize. It's $500.
What's the statute for simple possession, state?
Looking at it now.
It's $500. That's what it said.
$893.03.
893.03 per the state. Thank you, Madam Prosecutor. Thank you, sir.
You have a good day, Your Honor.
You too. Kenneth Jean Kenneth or Kenneth Jean? The court finds probable cause in your case for trespass and bond is, yes, ma'am?
I apologize.
Mhm.
The state has extended an offer of an adjudication of guilt, credit for time served, court costs, and no return, in which Mr. Jean would like to plead no contest.
That's fine.
May I approach?
You may. Mr. Jean? Is this your signature here at the bottom of this plea form? Have you read this plea form in its entirety?
Yes.
Do you understand that by entering your plea of no contest, you're giving up the rights on the plea form? Are you under the influence of any alcohol or drugs or medication at this time? Do you understand a conviction on this case will subject you to deportation if you're not a U.S. citizen? There is a sufficient factual basis. You are alert, you're intelligent, you're adjudicated guilty. How much time served?
3 days.
3?
Yes, Your Honor.
And you're ordered to serve 3 days in jail with credit for 3 days' time served. Further, you must pay mandatory court costs within 180 days of your release. I am releasing you as to this charge. And you must not return to the location where this incident occurred. Do you have any questions, sir? You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. You're excused, sir. Austin Bradshaw? The court finds probable cause for disorderly conduct and enters a release on recognizance.
Your Honor, if I may?
You may.
The state has offered an adjudication of guilt, credit for time served, and court costs, in which Mr. Bradshaw would like to plead no contest. Would the court be willing to take that?
That's acceptable.
May I approach?
You may. Mr. Bradshaw, is this your signature at the bottom of this plea form?
Ma'am.
Did you read the plea form before you signed it?
Yes.
Yes or no?
Yes, ma'am.
Are you under the influence of any alcohol or drugs or medication?
No, ma'am.
Do you understand a conviction on this case will subject you to deportation if you're not a U.S. citizen?
Yes, ma'am.
There's a sufficient factual basis. You're alert, you're intelligent, you're adjudicated guilty, and ordered, how much time, sir?
2 days.
2 days in jail with credit for 2 days' time served. Further, you must pay mandatory court costs within 180 days of your release. I am ordering your release as to this charge, sir. You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Any questions?
No, ma'am.
Thank you, sir. You may exit for your paperwork. Michael Henderson. The court finds probable cause for disorderly conduct and enters a release on recognizance.
Your Honor, if I may?
You may.
The state has offered an adjudication of guilt, credit for time served, and court costs, in which Mr. Henderson would like to plead no contest.
All right, that is acceptable.
May I approach?
You may. Mr. Henderson, is this your signature here at the bottom of this plea form?
Yes, ma'am.
Did you read this plea form, sir? Are you under the influence of any alcohol, drugs, or medicine this morning?
No, ma'am.
Do you understand a conviction on this case will subject you to being deported if you're not a U.S. citizen?
Yes, ma'am.
There is a sufficient factual basis. You are alert, you're intelligent, you're adjudicated guilty, and you are ordered to serve, how much time, sir?
2 days.
2 days in jail with credit for 2 days' time served. Further, you are ordered to pay mandatory court costs within 180 days of your release, and I am ordering your release as to this charge. Do you have any questions? You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Fabian Aviles. Mr. Aviles, the court finds probable cause for aggravated assault with a deadly weapon and orders the bond to be set at $1,500. The court orders you to have no contact with the victim, not to return to the location where this incident occurred, possess no weapons, no firearms, and surrender any weapons or firearms to law enforcement within 24 hours of release. Tyrone McGee. Mr. McGee, the court finds probable cause in your case for child abuse. Bond is set at $4,000, and battery, domestic violence. Bond is set at $500. The court is ordering you to have no contact with the victim. Victims, in this case, possess no weapons, no firearms, surrender any weapons or firearms to law enforcement within 24 hours of release. The court is ordering you to not return to the residence and maintain a separate residence with the exception of a one-time visit in the presence of law enforcement to recover personal belongings and effects. And the court is ordering you to comply with any DCF plan if when it's entered in this case, and since, based on your income, you do not qualify for the public defender is not appointed in this case. Jennifer Millspa. Ms. Millspa, you qualify for pretrial release, and I do find probable cause for count 1, possession of cocaine, and count 2, battery domestic violence, for which both counts. The court is ordering you released on pretrial release. You must comply with the terms of the pretrial release program. Further, you must have no contact with the victim, possess no weapons, no firearms, and surrender any weapons or firearms to law enforcement within 24 hours of release. Further, ma'am, you must not return to the location where this incident occurred with the exception of a one-time visit in the presence of law enforcement to recover personal belongings. Thank you.
Will there be random drug testing through PTR?
Is the state requesting that?
Yes.
And the basis because of the possession of cocaine?
Yes, Your Honor.
All right, the court will order that based on the state's request that you comply with the random drug test through PTR. I think it's automatic.
That's what I wasn't sure.
I don't know.
Oh, it's not. Okay. Not, Your Honor.
It's not, oh, I thought it was. Well, yes, you need to remind me to order it. I definitely needed to order it in that case. Yes, ma'am. Thank you. Clara Angelique Ramos. Ms. Ramos, the court finds probable cause for count 1, battery on a law enforcement officer, count 2, resisting an officer with violence, and count 3, battery domestic violence. That's count 1, bond is set at $1,500, count 2, $1,000, count 3, $500. There's a second case of battery on a Leo and resisting an officer with violence, and bond is set or stays set.
Your Honor, may be heard.
One moment, the bond stays set at $2,500 on count 1 and $1,000 on count 2. Conditions of bond are that you have no contact with the victim, possess no weapons, no firearms, surrender any weapons or firearms to law enforcement within 24 hours of release, and that you not return with the exception of a one-time visit in the presence of law enforcement to recover personal belongings and effects. And counsel, you may be heard.
Your Honor, the defense takes the position that there is no probable cause for both of these. It looks like it might have been a correction. Because it's the same report, just one charge is added, and then the agency case numbers are the same.
Well, the court takes the position that there are two different cases because the case numbers are different. And one of them is 2022 CF 10579, and the other one is 10589, and there are two officers involved. So the court finds probable cause, as I have noted. Anthony Shearer.
Your Honor, we'd ask to waive the reading of this charge.
Yes, ma'am. State you have no objection to that. All right.
No, Your Honor.
All right, the court does find probable cause. Bond is set at no bond on count 1 and $500 on count 2. The court orders no contact with the victim. The court orders no return, no contact with the minor children, comply with any DCF plan if one is ordered in this case, possess no weapons and no firearms, and surrender any weapons or firearms to law enforcement within 24 hours of release. Byron Taylor. Is this one that I needed PC paperwork? Was it, it was not, was it attached? Still don't have the PC paperwork on this one. State, do you have the PC paperwork on Byron Taylor?
No, Your Honor, I'm just given the,
Okay, State, Madam Clerk, can you look and see if there's additional paperwork on there? Okay. Yes, just print what you have, please. All right, the court, that's enough. Even though page 2 is missing, there's probable cause in page 1. The judge did sign the warrant as well. Just so everybody knows, I did not read page 2, but based on page 1, the defendant swung a knife and cut the victim with the knife. I guess defense, if you want to object to me finding probable cause, because page 2 is missing, you could. But I did not read page 2, so I don't have a signature.
no objection, Your Honor.
But the judge did sign the warrant. Okay. The court finds probable cause. Bond is set at $2,500. The court orders no contact with the victim. Possess no weapons, no firearms, and surrender any weapons or firearms to law enforcement within 24 hours of release. That you not return and maintain a separate residence. You can return one time in the presence of law enforcement to recover personal belongings. Timothy Zimmerman. Per jail staff, Mr. Zimmerman refused. We'll reset him for 24 hours.
Your Honor, if I may,
Yes, ma'am, you may.
I would waive his appearance.
All right, defense counsel is waiving appearance. All right, ma'am. Listen here, I'm gonna revoke his bond on the auto bond case and set bond at no bond. All right, as to the new law, aggravated battery on a pregnant person, the bond is, probable cause is substantiated. Bond is set at 3,500. Violation of PTR, bond is set at 500. And as I said, revoke bond on the auto bond. Bond is set at no bond on count 1 and no bond on count 2. Conditions of release: no contact with victims, not to return, possess no weapons, no firearms, surrender weapons or firearms to law enforcement within 24 hours of release. Greg Cooper. The court finds probable cause for battery, domestic violence. Bond is set at $500. Court orders that you have no contact with the victim, not to return to the location where this incident occurred, maintain a separate residence. You are authorized at one time visit in the presence of law enforcement to recover personal belongings and effects. You must surrender any weapons or firearms to law enforcement within 24 hours of release and possess no firearms or weapons as a condition of your release. Thank you. Emmanuel Geraldo. The court finds probable cause for battery, domestic violence, and orders a bond of $500. Orders you to have no contact with the victim, not to return to the location where this incident occurred, and maintain a separate residence, with the exception of a one-time visit in the presence of law enforcement to retrieve personal belongings and effects. You must possess no weapons and no firearms, and surrender all weapons and firearms to law enforcement within 24 hours of release. Madge Hoffman.
Your Honor, we'd wait for appearance.
All right, the court finds probable cause for battery domestic violence. Bond is set at $500. The court orders no contact, no return, possess no weapons and no firearms, and surrender weapons or firearms to law enforcement. Revoke bond on the out on bond case. Bond is set at no bond, and on the out on bond case.
Your Honor,
Yes, ma'am.
may we have a one-time return with law enforcement?
Yes, one-time return with law enforcement is authorized.
Thank you.
Praven Patil, the court finds probable cause for battery domestic violence. There's a witness, the court is intending to order the defendant to be released on the PTR program with the requirements of PTR, but let's go ahead and hear from the witness. Raise your right hand to be sworn in and make sure you speak into the microphone.
Okay.
You swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
All right, what's your name, ma'am?
My name is Naina.
What's your last name?
Naina Kapannis.
All right, ma'am. You can put your hand down. The lawyers may have a question or questions of you regarding this case.
Okay.
Good morning. What's your relationship to the defendant?
So I'm his wife.
Okay. And are you seeking contact with your husband today?
Yes.
Are you afraid of him?
No.
And has anything like this ever happened in the past?
Yeah, it happened, but wasn't that serious actually.
Okay. No further questions from the state at this time.
Ma'am, how old is the child that was with you when this happened?
So she was not with me actually. She is 4.5 years old.
4.5?
Yeah.
Was you and the child weren't going down to the lake or to the park?
No.
Okay. So the child didn't see what happened?
No, she didn't see it.
All right. Any questions?
No, Your Honor.
All right. The court finds probable cause and orders the release on the pretrial release program. No hostile contact with the victim. Possess no weapons, no firearms, and surrender any weapons or firearms to law enforcement within 24 hours of release. And even though the witness says there was, the child was not present, if DCF gets involved in this, Department of Children and Families, and they require a supervision plan, you must comply with the terms of the plan. Thank you. Thank you, ma'am.
Thank you.
Thank you.
Tina Rivera. The court finds probable cause in this case for battery domestic violence. In your case, the court notes that you do qualify for the pretrial release program, and I will be ordering the pretrial release program. We do have a witness, so raise your right hand to be sworn in. You swear that the testimony you're about to give is the truth, the whole truth, nothing but the truth?
I do.
All right, sir, I need you to speak into the microphone, and the lawyers may have questions of you. Go ahead.
Good morning. What's your relationship with Ms. Rivera?
She's my wife.
And are you seeking contact with your wife today?
I am.
Are you afraid of your wife?
I'm not.
And has anything like this ever happened in the past?
Yes.
If something like this were to happen again, would you be able to call 911?
Yes.
Okay. No further questions from the state at this time.
Any questions?
No, Your Honor.
All right, the court will order you to be released on the pretrial release program. Conditions of release: to have no hostile contact with the victim, possess no weapons, no firearms, and surrender any weapons or firearms to law enforcement within 24 hours of release. Thank you. Thank you, sir.
Thank you, sir.
Yalitza Enid Acevedo.
Yes.
The court finds probable cause for possession of cocaine and orders a bond of $1,000. The court finds, you also were picked up for failure to appear on or driving on a suspended license charge. Bond will stay at $500 on that. I think that covers it for you. Thank you, ma'am. Douglas Askew. All right, yes, ma'am.
We'd ask to waive the reading, we'd also waive his appearance.
All right, his appearance is waived by counsel. The court finds probable cause, bond is set at no bond. Court is ordering no contact with, victims or any minor children. Revoke bond on the out on bond case, and bond is set at no bond on the out on bond case. Alexis Ayala. The court finds probable cause for possession of cocaine. Bond is stayed at $1,000. The court takes no action on the out on bond case. James Willard Brown III.
Yes, ma'am.
The court finds probable cause for battery on a law enforcement officer. Bond stays at $5,000. Count 2 resisting bonds is set to $150, and count 3 trespass bond is set to $150. Further, you do not qualify for the public defender, so I'll not be appointing the public defender in your case. I am ordering you to have no contact with the victim in this case and not to return to the location where this incident occurred. Richard Campbell.
Yes, ma'am.
The court finds probable cause for smuggling marijuana or transporting marijuana, a Schedule I prohibited drug, into the state. Bond stays at $200,000. And possession of drug paraphernalia used to transport drugs, bond stays at $2,000. Revoke bond on the out on bond case, all counts. Bond is set to no bond on all counts.
Excuse me, Miss, can I speak?
Clarification, count 1, bond is set at 2,000. Sorry.
And Your Honor, bond on count 2 is 2,000 as well?
Yes, ma'am.
If you have a medical marijuana card, that is a defense. It's $2,000 for each count. That one's revoked. So you're gonna have to see the trial judge.
Chad Carr. Mr. Carr, the court finds probable cause in your charge of fleeing and attempting to elude an officer, and bonds is set to $4,000. And the court revokes the ROR on your,
If I may be heard?
yes.
Your Honor, we'd ask for no action to be taken on the case he's out on. This case happened in 2021. There's still no information filed, and at this point, it's outside of speedy for the state to file an information.
Okay, this state, is this correct, that it's outside of speedy for the state to file an information?
I'll verify that.
Okay.
I'm unable to pull up that case number in our system, so no objection to taking no action.
The court will take no action on the out on bond case in the event that it hasn't been filed yet. You can confirm that, right?
The case number doesn't yield any results.
Okay, let me give the case number to the clerk. All right, we'll just need to confirm that nothing's been filed.
Oh, it was my system not working, but
Nothing's been filed at this time.
All right, then no action on the out on bond case. Let me have it back. $4,000. Matthew Chisholm. The court finds probable cause for aggravated battery on a pregnant person. Bond is set to $5,000. The court is ordering that you have no contact with the victim, not to return to the location where this incident occurred, possess no weapons, possess no firearms, surrender any weapons or firearms to law enforcement within 24 hours of release. Aaron Cohn.
Good morning. How you?
Morning, the court finds probable cause for battery on a law enforcement officer. Bond stays at $2,500, and count 2, resisting an officer, bond stays at $500.
Yes, ma'am. That's it?
Thank you, sir.
Judge, he's currently out on bond. That's Combs?
I can't hear you, ma'am.
Was that defendant Combs?
Yes, ma'am.
He's currently out on bond. Ag assault.
May I have Mr. Cohn's paperwork back? Cohn. Yes, C-O-N-E. So first of all, we do not have any information that confirms that he is out on bond. And secondly, I can barely hear you talking. So,
For defendant Aaron Combs, he's currently out on bond in case number 2022 CF 00208-480.
And Your Honor, if I can be heard on that case?
well, I want Mr. Cohn back in here. Madam Clerk, have you been able to print that?
1 second. You just.
No, I need to know if it's been filed or just anything, if, what the counts are, what the bond is. They usually give me that, but I don't have it on this case. Mhm. So there isn't information? Okay. $3,500, 150, 150, 150? Okay. Aggravated assault with a deadly weapon. Aggravated assault with a deadly weapon, aggravated assault with a deadly weapon, armed trespass and structure. All right, Mr. Cohn, you have a case that you were out on bond on, and the court will revoke the bond.
Your Honor, may I be heard?
Yes, ma'am.
Your Honor, we'd ask for the court to take no action.
Mhm.
He's set for a competency hearing on September 16th in front of Judge Alvaro, and it does look like he just had a confidential evaluation done at my office.
So the court is going to decline, I'm going to revoke the bond, and I am going to set bond at no bond on all counts. However, you still have leave to file a motion, if it is appropriate to do so, to set bond. These cases are very similar in the charges, and so the court is revoking the bond.
So you revoked my bond.
Yes, sir, I revoked your bond.
How are they similar? This is not even. No. Man,
Yes, sir.
no, I need to.
I will reach out to your attorney right now and let him know.
But what is that gonna do?
So that he can get you out, because you don't have a bond right now. The only thing that can help you is me reaching out to your attorney right now, okay?
Thank you, sir.
I don't understand. How you just let me leave the courtroom, then call me back, and then say my bond is revoked
We'll
now?
figure it out, okay?
I don't understand.
I understand, but we're gonna figure it out, and I'll make sure Mr. Booty contacts you this week.
That's not even right, man. What about the money I paid for the bond?
We're gonna figure it out. So just go back there, we're gonna figure it out.
Thank you, sir. Viviana Dalbone.
Her bond, oh, yeah. Never mind.
I'm sorry? All right, bonded per the jail staff. You want me to throw them down here or give them to you? Okay. Joylis Delgado Soto. Delgado Soto. The court finds probable cause for grand theft, third degree of a motor vehicle. Bond stays at 1,000. You're ordered to have no contact with the victim, not return to the location where this incident occurred. Mm-hmm. For this case? So I already did this case. Delgado Soto, did they need the Portuguese interpreter? No. Okay. Evan Moon, that's who needs the interpreter? Monet? Okay. All right, Evan Moon. Or Monet?
Oh, okay.
And let's put the Portuguese interpreter on the line. Oh, I see.
Alô?
All right, Madam Interpreter, can you hear me? This is Judge Allen.
Yes, Your Honor, I
All
can
right.
hear you.
All right, can you hear the clerk? Madam Clerk, let's do a sound check.
I never heard anyone else besides
Can you raise your
Your
right
Honor.
hand, please? We can barely hear you, interpreter. Can you up your volume just a little bit?
Yes, yes. I am at the highest volume possible.
Okay, thank you.
100.
Do you solemnly swear to translate from Portuguese to English, from English to Portuguese, to the best of your ability?
I swear I do.
Thank you.
All right, we have a witness that we need to swear in.
E nós temos uma testemunha que também vai fazer o juramento.
Can you have the victim raise her right hand?
Você levanta a sua mão direita.
Do you solemnly swear and affirm the testimony you're about to give shall be the truth, the whole truth, so help you God?
E você promete dizer a verdade, apenas a verdade, nada mais do que a verdade, e para que eu possa ajudá-los?
Sim.
Please state your name.
Yes.
Please state your
Qual
name
é
for
o
the
seu
record.
nome? Por favor, diga o seu nome para os records.
Camila.
Camila.
And your last name?
E o sobrenome?
Curti.
Curtis.
Ma'am, can you please restate your last name for me?
Senhora, por favor, repita o sobrenome.
Curti. Ms. Corti? Is that what
Senhora
it is?
Corte.
Corti. Thank you. Ms. Corti, the lawyers may have questions to ask you about this case, all right? Okay.
Senhora Corte, os advogados talvez tenham algumas perguntas a fazer sobre esse caso.
Okay.
I'm afraid it's gonna reverberate.
It's very loud because the volume is turned up to hear the interpreter, so just don't get too close to the microphone.
Okay. Miss Carchi, what's your relationship to the defendant?
E, senhora Corte, qual é o nível de relacionamento com o réu?
Ele é meu namorado.
He's my boyfriend.
And are you afraid of him?
E você tem medo dele?
Agora eu tô com medo.
Now, yes, I am afraid of him.
Would you like to have no contact with him?
E você prefere não ter mais contato com ele?
Sim.
Yes.
Do you two live together?
Vocês vivem juntos?
Sim.
Yes.
No further questions from the state at this time.
Nenhuma pergunta adicional por parte do Estado nesse momento.
Does the defense have any questions?
Yes, Your Honor.
E a defesa tem alguma pergunta?
Will you be moving out or are you staying at the residence?
Você vai mudar ou você vai continuar naquela residência?
Eu não tenho para onde ir, ainda não.
No, it's not clear because she's crying. Repete, por favor, não ficou claro.
Eu ainda estou no apartamento.
Mas você vai se mudar do apartamento ou você vai permanecer naquela residência?
Eu vou ficar até encontrar um lugar, eu não tenho para onde ir agora.
I'm still in that apartment. I'm going to remain there until I find a place to live. At this moment, I have nowhere to go.
So I just want to clarify, are you intending to find a place to live? You just don't have a time frame?
Então, eu preciso aclarar com você. A sua intenção é procurar um outro lugar para você viver. Você ainda não procurou porque você não teve tempo.
Porque eu queria ficar no apartamento, mas eu tenho medo de ficar lá. E eu ainda não encontrei um lugar por causa de dinheiro. E eu ia ficar lá no apartamento, mas eu não sei se eu posso ficar lá. Eu ainda tenho que falar com a dona do apartamento, mas como é domingo, não consegui falar com o office.
No, actually, I would like to stay in that apartment, but now I am afraid of staying there. And main reason, I don't have money to pay for a place to live. So my intention is to talk to the owner of that apartment and see what kind of arrangements we can make. But I'm having difficulty because I am not bilingual. I can talk to her.
No further questions, Your Honor.
All right, thank you. All right, at this time, the court finds probable cause for battery, domestic violence. Bond is set at $500.
Your Honor, I believe he does qualify for pretrial release.
The court finds probable cause for tampering with a witness. Bond is set at $500. The court finds probable cause for false imprisonment. Bond is set at $2,500. The court is ordering, Miss Interpreter, are you not interpreting? You have to interpret what I'm saying. The victim can't hear, can't understand me.
Your Honor, you have to pause.
I am pausing. You are not interjecting. Now, when I speak, I pause, then you interject, okay?
Então, é um caso de violência doméstica e o preço que está sendo cobrado são $500. A advogada interferiu e ela está dizendo que esse tribunal vai fazer com que você seja livre de ter que pagar esses valores. Mas, enfim, eu estou em. A juíza.
Ms. Public Defender, respect. Stop talking while I am talking and the interpreter is talking. I don't want to hear your excuses. Just have respect.
I have to finish the last part. The release is $2,500. Então, para você ser liberada, você tem que pagar a fiança no valor de $2.500.
The court is ordering you have no contact whatsoever with the victim and that you not return to the location where this incident occurred.
Você não pode ter contato com a vítima e você não pode retornar ao mesmo local onde isso ocorreu.
You are authorized a one-time visit in the presence of law enforcement to recover any personal effects.
Mas você está autorizada de voltar lá mais uma vez, acompanhada pela polícia, para retirar as suas coisas pessoais.
You are ordered to possess no firearms or weapons as a condition of release.
E a ordem é que você não pode ter em mãos, portar revólver ou qualquer arma de fogo. Essa é uma condição para que você seja liberada, esteja livre.
And to surrender any firearms or weapons to law enforcement within 24 hours of release.
E você tem que dar todas as armas de fogo que talvez você tenha, revólveres, armas, você tem que devolver, dar para a polícia.
As to pretrial release, the court has no indication that this individual qualifies for PTR.
E como pré-tribunal, não existe nem uma indicação que esse indivíduo esteja, não existe nenhum, excuse me, Your Honor, no indication for PTR?
No indication that this individual qualifies for PTR.
Isso, não existe nenhuma indicação que esse indivíduo se qualifica para ter o PTR.
Can the PTR staff address that concern?
E o pessoal do PTR é o pessoal que vai cuidar dessa preocupação, desse aspecto preocupante.
In regards to, he didn't have any history, that's why he qualified for PTR?
I'm sorry, I think because I have the volume up so loud, you're it's an echo. Can you repeat that?
Due to his history, he qualified for PTR. He doesn't have any history and his community ties was verified.
Madam Interpreter, could you hear her?
Yes. Devido à história dele, ele não tem nenhuma história anterior, portanto, ele está qualificado para ter o PTR, ou PTR.
The court will modify the terms of release to bond plus PTR.
A corte vai modificar a liberação com pagamento de fiança mais o PTR.
And you must comply with the conditions of PTR as well as the conditions that this court has ordered.
E você tem que obedecer às condições do PTR, e também tem que obedecer às condições estabelecidas pela ordem dessa corte.
Madam Prosecutor, go ahead.
Yes, I was just hoping that while we have the interpreter, we could explain that no contact also includes no contact through third parties.
Ok, então, enquanto nós temos a intérprete, eu quero explicar para você, quando existe essa ordem de não contato, isso também inclui que você não pode entrar ou tentar entrar em contato através de terceiros.
To clarify, no contact with the victim includes no contact through third parties.
E aclarando, não contato com a vítima significa também o não contato através de terceiros.
No contact through electronic means such as email or telephone.
E nenhum contato por via eletrônica como e-mail ou telefone.
And no direct contact.
E nenhum contato direto.
Ma'am, do you have any questions?
No.
A senhora tem alguma pergunta?
No.
Anything further?
Algo mais?
Nothing further. No, Your Honor, may I have a moment with my client?
Madam Interpreter, thank you. You are excused.
Thank you, Your Honor. Have my pleasure.
Thank you.
Have a nice day. Bye-bye.
Ms. Public Defender, I need you to approach along with the state.
Yes, Your Honor.
Deputy, escort him out. All right, thank you, Ms. Public Defender. We are still on the record. We did not go off the record. And you've had a chance to speak with the defendant, the previous defendant, correct?
Yes, Your Honor.
Kelvin Flores Maldonado.
What about Ms. Speed?
Yes, I just have it out of order. April Feed. Ma'am, the court finds probable cause for possession of 3,4-methylene methamphetamine MDMA ecstasy. Bond stays at $1,000. And count 2 loitering or prowling. Bond stays at $250. Kelvin Flores Maldonado. Sir, you have 3 cases, and the court finds probable cause as follows. Case number 1, grand theft. The court finds probable cause, bond stays at $2,000. The second case, grand theft. Bond stays at $2,000, and the third case, petty theft, bond is stays at $500. The court is ordering that you have no contact with the victims and not return to the locations where these incidents occurred. Then bond is reduced to $500 on the petty theft case. No contact, no return. All 3. Seneca Howard. Seneca Howard. The court finds probable cause for possession of a firearm by a convicted felon, and bond stays at $4,000. And count 2, possession of cannabis, bond stays at $150. The court revokes bond on the out on bond case, and bond is set at no bond, all counts.
So, excuse me, ma'am. I have business that I work, I own. And
Sorry, sir, that's the court's ruling. Bond stays set, bond is set at no bond, all counts. Jean-Claude Justy. The court finds probable cause for aggravated assault with a firearm. In case number 1, bond is set to $5,000. Court is ordering that you have no contact with the victims, possess no firearms, no weapons, and surrender any firearms or weapons to law enforcement within 24 hours of release. And that you not return to the location where this incident occurred. As to your second case, fleeing and attempting to elude, the bond is set to $4,000. Thank you, sir. Dion Roshad Keys. The court finds probable cause for child abuse, count 1. Bond is stayed at $1,000. Count 2, stayed at $1,000. And count 3, disorderly conduct, bond is stayed at $250. Further, the court is ordering that you have no contact with the victims in this case, and no contact with any minor children under the age of 18, and that you comply with any DCF plan that might be entered in this case, that you not return to the location where this incident occurred, that you possess no weapons and no firearms, and surrender any weapons or firearms to law enforcement within 24 hours of release. Amara Leggett, thank you, sir. Amara Leggett,
Bonded.
previously bonded per jail staff. Michael Lewis. The court finds probable cause for count 1, possession of a firearm and ammunition by a convicted felon. Bond stays at $4,000. Count 2, resisting an officer without violence. Bond stays at $500. The court revokes bond on your out on bond case and increases the bond to $3,000 on count 1. I'm sorry, to $3,000. No, that's correct, to $3,000 on count 1 and $1,000 on count 2. Jalissa Ortiz. The court finds probable cause for possession of cocaine. Bond stays at $1,000. Count 2, possession of methamphetamine. Bond stays at $1,000. Count 3, possession of paraphernalia. The court sets the bond to $1,100. And your second case, for violation of PTR conditions, the court revokes PTR and sets a bond on count 1 of $2,500 and on count 2 of $500.
Your Honor, just clarification, count 3 on the new law, is that 1,100 or just 100?
100. 100. On the, oh, only one count was filed on. Which count was filed on? All right, so in the case where the court revoked PTR, bond is set at $2,500 on count 1, and count 2 was not filed upon per the clerk. Thank you, ma'am.
Your Honor, can you provide the case number she was out on PTR on? I did not get that.
Madam Clerk, can you give it that?
2022 CF 5321.
Thank you.
Chris Marks Philippe.
Yes, ma'am.
In your case, the court finds probable cause for robbery with the threat of a weapon, and bond stays set at $5,000. You're ordered to possess no weapons and no firearms and surrender any weapons or firearms to law enforcement within 24 hours of release. You're also ordered to not return to the location where this incident occurred and to have no contact with the victims.
Okay, ma'am, I don't understand. They charged me with robbery for 2 sandwiches from Publix. And I never had no gun. I never put no gun, no weapon at nobody, and I don't have the money to afford for $5,000.
Unfortunately, sir, that is the bond that the court has set. Your lawyer is able to communicate with you and determine whether a bond motion will be appropriate.
Okay, it says no weapons, firearms. So what that mean? Okay, but I never had one. That's why am I charged with robbery? Can I have a judge as petty theft or something?
I don't even understand what you're saying, sir. Sorry.
Because they charged me with robbery, and I never had any weapons. Never made
I heard you say that part, but you said something else.
This right here says no weapons, no firearms.
That means you should possess no weapons or firearms.
Well, can you help me out with dropping it to petty theft or something so I could be able to?
I'm sorry, sir, I do not drop charges. That's in the realm of the state. The prosecutor makes that determination. Thank you, sir. You're excused. Robert Stewart. Did I take yours out by mistake? The court finds probable cause for carrying a concealed firearm, and the court orders bond to stay set at $1,000, orders that you possess no weapons, no firearms as a condition of bond, and that you, as to the out on bond case, the court revokes the bond and sets a new bond of $1,000. Let's see here, one moment, don't take him out yet. The court is further ordering that you not return to the location where this incident occurred. And I think I already ordered to surrender any weapons or firearms, okay. Michael Taliaferro. Sorry. The court finds probable cause in your case for count 1, possession of a counterfeit driver's license. Bond is stayed at $5,000. Count 2, fraudulent use of personal identification information. Bond stays at $2,000. And count 3, fraudulently impersonating or intentionally impersonating someone with possession of 4 or fewer forms of identification. Bond is set at $150. Thank you. Michael Wisner. The court finds probable cause for count 1, trafficking in marijuana in excess of 25 pounds or 300 plants or more. Bond is stayed at $200,000. Count 2, selling marijuana. Bond is stayed at $15,000. Count 3, possession of marijuana over 20 grams. Bond is stayed at $1,000. Count 4, use of equipment or paraphernalia to transport drugs. Bond is set to $150. Count 5, smuggling or bringing Schedule 1 drugs into the state. Bond is set to $100. You do not qualify for the services of the public defender, so consequently, the court is not appointing a public defender. However, it looks like he just barely does not qualify, right? 4,000 a month? No. Oh, that's okay. Sorry, sir, you just don't qualify. Joel Kennett, oh, sorry. Is that the next stack? All right. No, I don't have the paperwork. It's in the office, right? Yeah, court's in recess for 30 minutes.
30?
30.